Hey, if you're preparing for immigration court and you're worried about getting it wrong, you are not alone. I've seen smart, well-meaning paralegals make the same avoidable mistakes that ended up costing them the attorney's trust, the client's case, and in some situations, even their jobs. That's why in this video, I'm walking you through the top 10 court prep mistakes I've seen again and again and how to avoid every single one of them. These aren't just technical slip-ups, they're preventable habits. And when you learn how to avoid them, you don't just support your team. You prove you're ready to handle real responsibility in court preparation. So let's get into it. But before we jump into the list, here's something I want to make clear. This video is not about pointing fingers or calling anyone out. It is about patterns, real mistakes that happen when there aren't clear systems in place. Whether you're new or experienced, these are things that trip people up all the time. I've seen them myself more than once. So if you catch yourself doing one of these things, it doesn't mean it's a failure. It just means your workflow needs a little tune-up. And once you fix those patterns, you don't just avoid mistakes. You make the whole process smoother for your team, your attorney, your client, and yourself. All right, mistake number one is forgetting to file Form EOIR 28. It's simple, but if it doesn't get filed properly, the attorney is not on the record. That means they won't get notices, and in some cases, they might not even be allowed to speak in court. If the case is electronic or ECAS, only the attorney can file the E28 through the portal. But for paper cases, paralegals usually prepare the form, get the attorney's signature, and serve it to both the court and DHS. Here's where things can go sideways. If you forget to serve one of the parties or assume ECAS automatically handles it, you can miss hearing notices. And that's how a client can end up with an in absentia removal order. To stay ahead of this one, first, you want to check whether the case is ECAS or paper. If it's in ECAS, remind the attorney to file it and confirm it went through. If it's paper, prepare the form, get it signed, and don't skip either service, court and DHS. And always save a file stamped copy because that's your proof the attorney's officially in the record. Mistake number two is just as critical and just as easy to miss, and that is forgetting to file Form EOIR 33. The E33 is the respondent's official change of address form. It tells the immigration court where to send future hearing notices. And if that form never gets filed, well, the court has no obligation to track the person down, and it will just send notices to whatever address is already on the file, even if that address is years out of date. I've seen so many cases where people missed their hearings and got ordered removed in absentia because no one updated the court after they moved. And here's the part a lot of new paralegals miss. Even if your client tells you they moved, you knowing it does not count. If there's no E33 in the record, then the court never heard about it. And just like the E28, the E33 is usually one of the first things we file, especially if the client changed addresses before hiring the attorney. We often file them both together. So here's how to avoid this mistake. Ask about any recent address changes during the intake or immediately after. Always file a new E33 anytime the respondent moves. For ECAS cases, this is important. The E33 has to be filled out outside of the system, usually in PDF format, using your firm's software. The respondent needs to sign it, and then it's uploaded manually to ECAS. That's different from the E28 form, which is filled out directly in the portal and doesn't need a client signature. For paper cases, paralegals usually prepare the E33, get it reviewed and signed by the attorney, and serve it to the court and DHS. And always keep proof of submission in the client's file, either a printout from ECAS or a stamped copy from the court, just like you did with the E28. Now, mistake number three is probably the one I see the most often, especially when paralegals are just trying to be efficient, and that is misusing templates and failing to proofread. Now, don't get me wrong, templates are helpful. They are how we stay consistent across cases. But when you rely on them without really reading what you are sending, well, that's when the problems start. I've seen motions addressed to the wrong venue, a numbers copied from another client, case summaries that still have facts from a completely different case. And it's usually not laziness, it's just people rushing, assuming the template is close enough. And in court, close enough doesn't really cut it. Judges notice when things feel sloppy. And if you're working with a supervising attorney, they will lose trust fast if they keep finding basic copy and paste errors in your work. It makes it look like you're not really paying attention, even when you are. And it can hurt your credibility fast. You will want to avoid this one by using templates as a starting point, not a final product. You should always update the case-specific info, such as names, A numbers of the respondents, dates, and venue. Read it out loud if you need to. It helps catch mistakes your brain wants to skip. And if you're reusing a motion or declaration, double check everything. Don't let your software autofill with wrong information. Review it before you send it. Mistake number 4 is a big one, especially when your caseload starts to grow, and that is not tracking deadlines or creating follow-up tasks. In immigration court, there are deadlines everywhere. Orders from the judge, motions filed by the DHS, and if you're not tracking those clearly and consistently, something's going to fall through the cracks. And sometimes the consequences are serious. Take this example. The court issues a scheduling order directing respondents to submit written pleadings within 30 days, and no one responds. If DHS has already established removability, usually just by filing the notice to appear, the judge can enter a removal order just because pleadings were not submitted. That's how high the stakes are. There are also short windows to respond to things like DHS motions, which are usually only 10 days. If you miss those, the court might rule without hearing your side. And here's how to stay on top of this. As soon as you get a hearing notice, motion, or court order, scan it for deadlines. Add them to your calendar or case management system right away. Set various reminders before the deadline, not just the day off. And don't forget follow-ups too, like checking with the attorney or requesting a translated document. Missed deadlines don't just slow a case down, they can end it. And when you are the person keeping track of everything behind the scenes, being organized is not optional. It's part of protecting the client and the firm. Mistake number 5 is one that doesn't usually blow up right away, but when it does, it can get messy fast, and that is not uploading documents to the case management system or your firm's shared drive. I know how it happens. You scanned a filing, you emailed the attorney, you even printed a copy for the physical file, but you never uploaded it to the case record. So now no one can find it. And if someone needs it fast during a hearing, for a filing deadline, or in response to a request, you're stuck digging through inboxes or folders that only exist on your desktop. And this isn't just about your own organization. Most immigration teams work across multiple cases, multiple paralegals, and more than one attorney. If you're the only person who knows where something is, well, that is a problem. Here's how to avoid this mistake. Upload everything as soon as it's ready, be it filings, receipts, signed forms, notices, or declarations. Name your files clearly, including the A number, what the document is, and the date. Use the firm's naming conventions if they have them, but if they don't, create your own and stay consistent. Avoid keeping critical documents only on your computer or email. If it's not backed up, well, it's not safe. Mistake number 6 is one of the easiest to overlook until something goes wrong, and that is not documenting client communications. Immigration cases can take years. Clients move, attorneys change, paralegals rotate in and out. And if there's no record of what was said, when it was said, and what the client was told, you're not going to be able to piece it back together later. I've seen it happen too many times to count. A client insists they were never told to bring documents, or someone from the team calls to request something, then another person calls later asking for the same thing. It makes the firm look disorganized, and it makes the client lose confidence fast. And good notes don't just protect against confusion. They help new staff pick up where someone else left off. If the paralegal on the case changes, those logs tell the story: what's been done, what still needs follow-up, and what's already been explained. Here's how to protect the case and yourself in these situations. After any call, in-person meeting, or WhatsApp message, log the interaction: date, time, what was discussed, and any next steps. Use your firm's case management system if they have one. If not, keep a clean and searchable record elsewhere. Don't rely on memory. Even short notes like called clients and they confirmed they will bring documents to the biometrics appointment can save you later. And finally, never delete or overwrite logs. Just add new entries. Mistake number 7 is not verifying whether documents in another language have been translated and whether those translations meet the court's requirements. This comes up most often with things like birth or marriage certificates. If the document isn't in English, the court requires a certified English translation, no exceptions. And that translation needs to include a certificate of translation, which is a short statement from the translator confirming they're fluent in both languages and that the translation is accurate. I've seen paralegals prepare entire filings only to realize right before submitting that several exhibits are still in Portuguese or Spanish. At that point, you're stuck. Either you scramble or you miss the deadline. And here's how you stay ahead of this one. During intake, flag any document that isn't in English. Request certified translations early, especially for birth, marriage, or divorce records. Make sure every translation includes a proper certificate. Review translated documents before filing them. They should be clean, labeled, and complete. Hopefully, you won't find yourself needing a stack of documents translated right before a crucial deadline. But if you do, I've included in the description a link to a trusted translation provider that can help you out quickly. Mistake number 8 is mishandling evidence or uploading things incorrectly through ECAS. Submitting evidence to the court isn't just about having the right documents. It's about sending them in the right format, the right order, and on time. And when you're using ECAS, mistakes stick. Once something's uploaded, it's in the record, and you usually can't add it or replace it without filing a motion. I've seen paralegals accidentally upload the wrong version of an affidavit, label exhibits out of order, or forget to merge PDF files. And that becomes part of the official record unless you move quickly to fix it. That's why ECAS isn't just a tech task, it's a legal one. Here's how to stay sharp when filing through ECAS. Triple check file names, exhibits, and page numbers before uploading them. Keep everything clearly labeled and consistent. Merge PDF files so each exhibit is one document, not 20 loose pages. Follow formatting rules, which is black and white, OCR readable, undersize limits. Don't hit submit until you've confirmed everything is complete and accurate. Save a full copy of what you filed, including the confirmation page or ECAS receipt. This is crucial because once it's at ECAS, it's in front of the judge and DHS too. A sloppy submission can cause confusion, delay, or worse, damage your credibility. Getting it right the first time isn't just about organization. It's about showing the court that the case is being handled seriously. Now, mistake number 9 is one that slows down a lot of new paralegals, and that is waiting on the attorney instead of taking initiative. When something needs to happen, whether it's following up with the client, checking a deadline, or flagging a missing document, some paralegals freeze. They're afraid of overstepping, or they're just used to waiting for directions. But here's the thing. Immigration attorneys are usually juggling dozens of cases, hearings, filings, sometimes all in one week. If you see something that needs to move forward, flag it right away. Take the first step. Prepare the draft, ask the question. The best paralegals aren't just responsive, they are proactive. Here's how to start building initiative into your workflow. If you spot a missing document or deadline, say something early. Don't assume someone else will catch it. Get in the habit of asking questions like, what's the next step here? And then take it. Prepare drafts or outlines when appropriate, even if they will need review later. That saves time. Follow up on emails, filings, and client requests without waiting for a reminder. If initiative is what turns a good paralegal into a great one, it shows your team they can count on you and that you are not just there to do tasks, but to move cases forward. And that's how trust gets built. All right, we finally got to mistake number 10. And if you are enjoying this video thus far, please make sure you leave a like and subscribe to our channel. All right, mistake number 10 is a big one, and it usually shows up late in the case, and that is not preparing the client for what court is actually like. I've seen clients show up thinking it's going to be a casual appointment. They don't understand what the judge will ask. They don't know how long it'll take. And in some cases, they haven't looked at their affidavit or declaration in a long time, especially if it was submitted early in the case. The attorney is responsible for preparing the client for testimony, but the paralegal plays a huge role in helping the client feel ready. You're often the one explaining logistics, reminding them what to bring, or helping them understand what kind of questions they will hear. And when clients are confused or overwhelmed, it shows. Even a strong case can completely fall apart if the testimony doesn't land, especially in asylum, where credibility is everything. Here's how to help your client walk in confident. Make sure they review their own affidavit or declaration well before the hearing. Go over what the court building is like, or who will be there, and what they should bring. Set clear expectations. Explain that the final hearing won't be a short or informal meeting. Remind them to answer honestly, take their time, and don't panic if they don't know something. Immigration court can be intimidating, but it doesn't have to be a surprise. When a client walks in prepared, they speak more clearly, stay calmer under pressure, and feel like they're not facing it alone. That can make all the difference, especially in cases where everything depends on their testimony. So those are the 10 most common mistakes that can quietly derail a case if you're not careful. If you've made any of these mistakes before, well, you're not alone. Most of us learn them the hard way. The key is to not repeat them and to start building habits that keep your work sharp, your team organized, and your cases moving forward. None of this is about being perfect. It's about being aware, because when you know exactly what to watch out for, you don't just protect the client. You make yourself indispensable to the team. And if this video helped you in any way, let me know in the comment section, or share a lesson you've learned in your job. And if there's a topic you'd like us to cover in a future video, drop a comment down below as well. This channel is for working and aspiring immigration paralegals, and your input
really helps shape what's next. And hey, don't forget to like the video and consider subscribing so you don't miss what's coming next. Thanks for watching. Keep your steps steady and your purpose clear. I'll see you in the next one.